Hello, this is Dave Siegel. Thanks for joining us for part 2 of our DUI topic. This is Legal Action. I'm joined with my co-host, Jesse Barrientos, DuPage County Attorney. And once again, we have Officer Cawthor from the Itasca Police Department, a 17-year veteran who's discussing DUI and the procedures involved with that. And just to take up where we left off last month, can you tell us a little bit about the field sobriety test that you administer?
Well, like we talked last time, and thanks for inviting me back. Like we talked last time, the field sobriety tests that I typically do, are the ones that are approved by the National Highway Safety Administration. And that would be the one-leg stance test, the walk and turn test, and the HGN, or the horizontal gaze and nystagmus test, are the typical 3 tests that I would do on every stop.
Okay, and the most common of those being, or the one that you feel is the most
reliable?
Most obvious in terms of you making a decision on whether to place somebody under arrest?
Well, I would say that they all play probably just as much importance in making that decision. I got my own feelings about which test is actually the one that is best for indicating it, which I think HGN by far is one that I don't think anybody can beat if you're in good shape or you're good with balance. Some people, or if you're an alcoholic, where you operate at a high number or high alcohol level, sometimes can do balance really good, where the HGN, you can't control it. I think that's a very, very good test.
How about, and now we're at the point before you've actually placed somebody under arrest for driving under the influence. The portable breath test, is that something that your department uses? Is it something that you use?
It's something that our department uses, and I feel that quite a few departments now do have portable breath tests. And yeah, we do use those.
For the layman out there, what's involved with that test?
Well, the portable breath test is after you've given your field sobriety test and there's an indication they've been drinking, you can ask them to take this portable breath test, which is a little portable unit. I mean, it's only a couple inches by a couple inches that we carry in our cars, and it's battery powered. And what we do is we'll ask them, I'll ask the driver if they want to take a portable breath test, and they get the right to take it or refuse it. I'm not going to force them to take it, but if they're willing to take it, I will administer a portable breath test that will indicate basically what their BAC is, blood alcohol content is, or their alcohol level in their system.
And, as long as we're on that, I recall reading something recently in terms of new technology coming out for police departments that was a flashlight that was kind of equipped with a sensor for exactly.
Alcohol?
I think they cost something like $700 or $1,000 or whatever, and I read a little blurb about something like that. So when you come up to the window and you
hold the flashlight,
shine it in there, it takes the sample kind of automatically. Well, I guess it's the same principle.
Seems like a great concept, but even with our portable breath test that we use an AlcoSensor portable breath test. We do ask them if they want to take it, and I would say, like we talked on the last show, I did 85 DUIs, and out of those 85 DUIs, I would say it's probably 50-50 on people will take it. A lot of people will refuse that test because they've either been advised by the lawyer or advised by a good friend never to take tests that you have to blow into.
And that's not the test that we're actually talking about that you would perform back at the station.
No, this is only a probable cause test that you're given on the street to show that they've been drinking and one that they're under the influence of alcohol.
Is that test admissible as evidence?
You can use it in your summer suspension hearing, but you can't use it in your trial. I believe the only way you can use it in trial, and you guys can probably answer this better than me, is if it's brought up by the defense, I believe.
Okay. Well, I think we hit all of the tests that you talked about. In some instances,
I think it's time to book the guy.
Okay.
Where do we go from here?
Well, once it's been determined that they're going to be placed under arrest for under the influence of alcohol, I would inform them that they're being placed under arrest for that. I would then have them walk over to my car and put their hands up on the car. I'm going to search them to make sure that they don't have nothing on them that they shouldn't have on them, weapons, drugs, anything they shouldn't have. Once they're searched, most officers will handcuff those subjects and put them in the back of the squad. I personally, and my chief's probably going to turn his eyes on this one, but usually I don't handcuff. I will place them in the car without handcuffs. And the reason I do that is I think it gives the people a better feeling that they're not being treated as a criminal. And that's just my own thought on it.
Are you doing this arrest solo, or are you calling for any kind of backup?
Sometimes it's solo. Sometimes we do have backup. Typically, we will have backup. Other officers in other zones will automatically come over, make sure everything goes good until the rest is done.
What do you do if there's other passengers in the vehicle? Are you taking everybody to the station? Or
No. I only transport the driver, and I will bring other officers. If I don't have somebody there, usually there's more than one person in that car. Usually we will get backup no matter what, because just the fact it's more chances of something going wrong with there's more people involved. But we will bring in another squad car to transport passengers back. Or I do have the option of talking to those passengers and seeing if anybody in that car has a valid driver's license that hasn't been drinking, and then allow them to drive with the permission of the owner of the car.
Okay. Sure.
I can allow them to drive. But no, I would never transport. I would only transport my arrestee, the driver of that vehicle, back by himself. I would never put somebody else in the back seat with him. And then, like I said, once he's placed under arrest and he's searched and placed in my car, well, then you got a whole other view of going and searching that car that he just got out of. We tow all of our vehicles. If there's nobody in that car that can drive it, or somebody following them that isn't drinking and doesn't have a valid driver's license, we automatically tow those vehicles. It's the policy of our department. Before we tow that vehicle, we do inventory of that vehicle to make sure what's in it, and so that we make sure that same contents are returned to that driver. But when we're searching that vehicle, we do look for other indications of the drinking itself. I mean, you're looking for open containers, you're looking for alcohol products, you're looking for drug paraphernalia and drugs. There could be various things in that car that could help you on your case, and that's what we're looking for.
So that's an inventory of the entire car, including the trunk?
We'll go through the trunk also.
Everything else?
Yep.
And actually, kind of a thought occurred to me when you mentioned, if there's a passenger that doesn't have a valid driver's license. Now, what happens if you're, not really close to any place where somebody could walk or anything? What would happen with the passenger who doesn't have a valid driver's license and who's with the guy that just got arrested?
Well, and that's a good question. If there's passengers in that car and say they haven't been drinking, and say, hey, we want to walk to the local Dunkin' Donut or the restaurant down the road, we would allow them to walk. The other thing you got to remember too is nowadays I think just about everybody, and I shouldn't say everybody, but just about everybody has cell phones, and most of those people will call for their own ride and make their arrangements. So if they ask and they haven't been drinking, we'll allow them to walk to a restaurant or a gas station and make their own arrangements. We have no problem with that. But if they've been drinking, then the passenger's also been drinking, we're not going to allow them to walk. I mean, we're not going to take somebody off the road that's been drinking because of a safety hazard.
Sure.
Even if you're walking and you're intoxicated, you're still a safety hazard. I mean, you could walk in front of a car, you could cause an accident with the cars, or you could hurt yourself. So what we'll do is we'll transport them back to the police station, and then we'll make arrangements to get them home from there, either taxi or call them for a ride.
A little off the books, but I mean, there is a statute on the books, right, with respect to public intoxication?
Yes.
So even if I'm not driving or if I'm
right, we're not going to allow you. We're not going to allow you to walk if you're intoxicated. You can hurt yourself or somebody else, and we're just not going to allow that. It wouldn't make any sense on our aspect of it. And also, out of that too comes back to the drivers. You brought up the question about the PBT. What if they don't blow over, a .08, which is a legal limit in Illinois? What do you do with those drivers that blow under? And there's a couple different ways you can look at it. Can somebody be charged that blows under a .08?
Let's throw an example out there. Say it's a .6.
So we're talking about the portable breath test just initially, or are we talking about the one back at the police station?
Well, let's cover the PBT first,
Okay.
then we can go back to the one in the station. If they blow under, I have a couple of options. One is if I think that they're still unsafe to drive, they still could be arrested for DUI. I mean, that doesn't stop it just because they blow under a .08. I mean, anything from a .005 can be charged with a DUI depending on other circumstances involved. Maybe they're also under the influence of drugs, or maybe they're under medications. But there can be a variety of different reasons why they could still be charged. But say they blow under a .08 on the PBT on the street. I have a couple options of one, depending on how low they are, and if I think they're safe to drive, I could allow them to drive. Or I could still take them off the street and make arrangements to have them get a ride. Most of the time when they blow under, I mean, you got to remember too, when did they stop drinking? So that goes back to my questioning of them when I first pulled them over. When's the last drink you had? And if they say they just drank just before getting in the car, before me pulling them over, they could still be going up.
Sure.
So at that point, I got to make a determination. Hey, they could be going up, and yeah, I got a low reading right now, but in another half hour they could be legally over.
So the longer, the more time that elapses, the more the blood alcohol concentration becomes.
Well, at some point it climbs up, and then at some point it goes back down. And depending on where I got that traffic stop, I don't know all the times if they're going up or they're coming down. So if he blew a low number and he's coming down, well, he's only going to get lower. But if he blew a 7, he could be going up. Okay. Even though I don't got the 8 on that portable breath test, I'm not going to arrest him, but I still got to make the determination if I'm going to allow him to drive. If I think he's going to be over in another half hour, I'm not going to let him drive. I'm going to bring him back to the station and make him get a ride or make arrangements so he doesn't have to drive.
Okay, so now that you've transported the arrestee back to the station,
yes.
What do you do from here?
He would be brought to the booking room. One of the questions I'll typically ask as soon as we get to the booking room is, when do they need to use the restroom? A lot of times it's very typical they want to use the restroom, so I'll let them use the restroom. Once they get back from the restroom, or if they don't have to use the restroom, I'm going to ask them if they have false teeth or any kind of partial that can come out of their mouth, or if they got gum or any other items inside their mouth. If they have anything in their mouth that they can remove, I'm going to make them remove those items. And then what I'm going to do, once all that's done, I'm going to read them what's called a warning to motorists. And the warning to motorists is going to explain to them basically what's occurring and gives them the different choices they have of taking a test at the police station or refusing it, what the consequences of it. It also talks about if you're a CDL holder, a commercial driver's license. It also talks about if you're under the age of 21. And it also talks about if you're a school bus driver and what those consequences are if you take the test or you refuse it. So that'll be read to them. And then what I do once that's read is a 20-minute observation has to take place. And then I observe them for 20 minutes to make sure they don't take anything into their mouth or they regurgitate or burp or anything happens in that nature.
You do that personally?
I do that.
You watch them personally
yes.
for that 20-minute period of time?
Yeah.
Let me ask, let's say that we have an individual who is over 21, who's doesn't have a commercial driver's license or is not a bus driver, first time, never received a DUI before. What can he expect to look at? Number one, if he goes along and he does cooperate and he does blow with the breathalyzer that we're gonna talk about now at the station in a couple minutes here, and goes along and cooperates, goes along with the program, how long can he expect that his license may be suspended?
Well, if you're using the example of a first-time offender, not under the age of 21, doesn't hold a CDL license or a school bus driver's license, what they're looking at is, and I'm going to explain in that warning to motorists to them,
sure,
that they're looking at is if they take that test and they blow over a .08, they're looking at, if they take the test, they're looking at a 3-month suspension.
Now, what about somebody who refuses to do the blow?
And they would be looking at a 6-month suspension. So basically, it's double the suspension time.
And I think it might be just a little bit fruitful for the folks at home that we kind of mention what the statutory summary suspension is. We're dealing with two different issues here, right? We're dealing with one is the underlying DUI, driving under the influence charge,
correct,
or charges, as the case may be, and there are two, right? There's the presumption.
There's a presumption, and then there's action for being over the legal limit.
So there's the impairment state. So there's two, and generally they get charged with both of them. Is that how that normally works?
Well, basically, what would happen is when I brought them back to the station, read that warning to motorists, if they decided to not take the test, they're charged with 1 count.
Under the impairment?
Under the impairment.
Okay.
And then if they take the test, they're charged with 2 counts because you got to blow over. So you know that they're over the influence or the 0.80.
Okay. So we have that, the underlying DUI case. But now, we also have, because their driving privileges is just that, it's a privilege. So now they're going to be suspended. So the summary suspension is what? How would you describe it? Is just kind of a civil in nature? There's a different burden of proof, whereas, for example, for the driving under the influence, it's beyond a reasonable doubt.
Right.
For the summary suspension,
right,
it would be just
and that's administered to the Secretary of State.
Right, to the Secretary of State. So that person is going to get the double whammy. He's going to have the criminal charges plus his license suspended.
Right.
Okay.
Exactly.
Now, within that statutory summary suspension, there's also the stiff portion, which I believe is 30 days of no driving at all. And then they can apply for a judicial driving permit for the remaining?
I think on the 31st day of that suspension, they can get a judicial driving permit. Correct.
Well, let's kind of just back up just for a sec, too, and kind of mention that generally, depending, when you go in and if you hire a lawyer and you go in for the first thing, that I would normally do would be to file a petition to rescind the statute of summary suspension. That has to be done within 90 days from the date that that's given. And basically, that's a mini hearing. That's not on the criminal charges. It's just to determine whether or not what the officer had probable cause to stop you, whether or not you were driving or in actual physical control of a vehicle, whether or not he gave you the warnings, those kinds of things.
Back to your petition. When would the statutory summary suspension kick in if you didn't file your petition to rescind? How many days after the arrest?
If you didn't file, well, on your first court appearance, you would, when you were arraigned, the judge would, would ask whether or not you're going to confirm it or contest it, and you'd still have an opportunity then to do it. We always, kind of as a matter of course, just go ahead and file those because you can always withdraw them, or as you said in our example, we're dealing with just a first-time DUI person. If with something that's going to be pled and negotiated out, he'll get his judicial driving permit. There's some other requirements for that, but he'd be able to get it, and so you can kind of withdraw. I just wanted to make sure that everybody is aware and they know that you're dealing with when you drink and drive, there are going to be more consequences than just the underlying criminal case, too. It's going to be the suspension of your driver's license. And if you think that it's difficult to get around now, without having your license, I didn't mean to kind of.
Especially if you don't live in the city where you can just hop on a bus
Exactly.
or a train.
Right.
If you're in the suburbs, it's a difficult chore to have somebody drive you around.
And just to back up on that summer suspension, when I'm charging that driver with driving under influence, I set the court date on the night that I have him under arrest, and he's given a copy of when he needs to appear in court. I set that court date within a guideline. It's got to be booked within a 26 to 42-day time period from the day that he was arrested. So he's going to be going to court for the summer suspension hearing within that time.
But then, okay, I understand your question. Now,
Yes.
it goes into effect the 46th day after the arrest. The suspension would, barring any, whether or not it was rescinded. If you were successful and it was rescinded, then there would be no suspension. You still have the underlying case.
What I was getting at is the immediacy of the suspension doesn't kick in right away.
Right.
No,
It's sometime after the arrest. The stiff suspension, when I say stiff, meaning 30 days of no driving, that kicks in unless there's a petition to rescind on file.
exactly. And to tell you the truth, when I release them that night, they do have a valid driver's license to drive until they go to court. But they are advised before they leave that they are not to drive that night.
Well, that's a nice segue.
Because they could get arrested again.
Getting back to this point, you've got them in the station, you're observing them. Let's say they refuse to blow. Where do you go from there?
Then they're basically processed for that DUI. And that the processing procedure is basically they're going to be fingerprinted, photographed, and then I got to do a ton of paperwork before they're going to be released.
What kind of time frame, though, until they can be released are we looking at if they're arrested in Itasca?
Well, usually what you're looking at, it depends on if somebody comes and assists me. A lot of times a sergeant will come down and do some of the typing so we can move it along faster. But a short amount of time would be an hour and a half. Typical would probably be 2 to 2.5 hours to do a DUI by myself, where I'm doing all the paperwork. And it depends, that's just to get them out the door. And that also is making arrangements to get them a ride home. Sometimes they'll call somebody and the person don't show up for 2 hours or 3 hours. But majority of the time they will take a taxi, which we can get there pretty fast.
So when they bond out, again, first time that we're talking about, right?
Right.
Do they have to post any money?
There's a bunch of different options. They can either post the money or they can be issued a I-bond, which is mean getting out on their signature.
Okay.
And my own belief on this is when I'm doing my DUIs, if you're cooperating and I have no problems with you, most of the time I will push for an I-bond with my sergeant. So the sergeant has to approve an I-bond, and it's his discretion on how he wants to go with it, but I will push in your favor to get you that I-bond if you cooperated all the way through the process. Why punish you further? I'll try to help you out.
And if you didn't, then you have to pay some money, and if you don't have the money, then you're going to have to wait for somebody to bring it, right?
Right, exactly.
Okay.
Exactly. And if they had to post money, if they got a valid driver's license, it'd be a valid driver's license plus $100. Or if they don't have a valid driver's license, it's $300. So actually the bond on a DUI is $3,000 or 10%. And they'd post the 10%, which is $300. And then if you got that valid driver's license, you can post a driver's license and then $100. Or if you don't have a driver's license, it's $300 cash.
And if it's 3:30 in the morning, it might be hard to find somebody who's willing to get over there with that money.
Yeah, it could be very tough, and a lot of people do have problems with coming up with that money. And then we would have the option of holding you until you could come up with that money. So say it's 3:30 in the morning, we might hold you till 8, 9 in the morning until you can get that money to come down.
Can you reduce it to an I-bond once they're there for 12 to 14 hours?
With the approval of a sergeant, it could be reduced to an I-bond at any time.
Okay.
But usually once they make their mind up, it's pretty hard to get them to change it.
But keep your phone on, Dave, because I'm going to call you. I'm just telling you that right now.
Right. So when is the next time the arrestee would see you once they leave the station that night or that morning?
The next time they would see me would be at the summary suspension hearing. And we have set summary suspension hearings, like my summary dates are every other Thursday. So every other Thursday at 8:30 I'm in court, and then I go through all my summary suspensions. Now, because I do a lot of DUIs, I actually use every Thursday, because otherwise I was having between 10 and 15 cases on a court call day, and it's just too much for me.
So we can see you in DuPage on Thursday.
If you come down, definitely you'd see me. If you want to sit down and talk, you're more than welcome, and welcome to invite you to sit down with me.
Thank you. While we have a few minutes left, I'd like if you can just describe to the audience in general terms what your likely success rate is on a DUI, what percentages off the top of your head are pled, how many are successfully beat where it's found that you didn't have probable cause, that you didn't follow some procedure properly. Can you just describe that in general terms?
Well, my exactly plea rate of guilties and not guilties, I'm not sure, because a lot of times, a lot of these court hearings take place when I'm not there. I'm not at the actual, when they plea out, because they can keep getting continuances. And at that point, I know when my first summer suspension hearing is, but if the lawyer asks for another date and continues it a few times, I'm not called in on that unless he subpoenas me. So I wouldn't even know when they plea out. And I don't check the record. There is records you can check to get that actual rate, and I don't have it. Do I lose some? Yeah, I do lose some. Most of the time, though, I am very successful on my DUIs.
Of the 100 or so that you've done in the last year, can you identify or state how many of those have actually gone to a full trial on the underlying DUI?
This year, now you got to remember, a lot of times to go to these trials, it takes a while for it to get to that actual trial. This year, I think I've had 3 trials. Now, when I say 3 trials, them are from DUIs that were in 05. So I'm not actually doing the ones this year yet. I think I might have had one from this year already. But usually it takes a while to get it into that trial process or that trial stage.
You handle the DUIs, but I think you would make an excellent witness, don't you?
I think so. Let me add, which of those were bench or jury, or kind of a mix of both?
Majority are bench. I haven't had now you got to remember, I came back to the street in July of 2005. So I had been off the street for 10 years in investigations. But prior to that, I did a lot of DUIs before I went into investigations. I think my whole career, I've had probably 4 jury trials on DUI cases.
Most of them end up actually pleading out. It just depends on the circumstances. It depends on the individual's resources as well, and whether or not it's a first-timer, or whether or not he's had or she's had 2 or more. Actually, we've got just a few minutes left. I have a question that I think would be beneficial for everybody to kind of know, because it's something that could be an honest mistake, but unfortunately ignorance of the law is still no excuse. Now, what happens, because it's not just driving under the influence of alcohol, but it's also drugs as well. Now, suppose I've gone to the dentist and had a root canal, and the doctor, the dentist prescribes for me some medication, Vicodin, which is kind of opiate based, and it kind of impairs your judgment a little bit. But it's a prescription, and I'm supposed to take 2 of these every 3 times a day. So say I did that and I'm driving. Am I going to be okay? Is that going to be a problem if I meet you?
Well, that's a very great question, and a lot of people do ask this. If you're under prescription, if you look on your prescription bottle, it'll tell you if you can operate machinery or drive a vehicle. You need to read that, because if you go on the street while you're under that medication, you can be charged with driving under the influence of alcohol or drugs alone or alcohol alone. So, yeah, you could be charged. If you're driving under the influence of a medication that doesn't allow you to drive, you could still be charged, and that does happen.
Even if it's a prescription,
Even if it's a prescription, you can be charged with driving. I want to say out of the 85 I've done this year, I got either 1 or 2 of them that are driving while they're on prescriptions, but it was prescriptions that you're not supposed to drive under. Yeah. And you know what? You see the same clues as driving under the influence of alcohol as prescriptions. It's the same exact clues: improper lane usage. You don't have the strong odor of alcoholic beverage if it's under influence, But then I look for other indicators that would indicate that they're under the influence of drugs.
Sure.
And one of those things would be is looking for prescription bottles, or even ask them, are you on medication?
And they would
That's one
say-
of the questions I do ask when I stop, even under driving under the influence. I'll ask them if they're under any medication.
Sure.
And then I'll ask them what that medication, and I'll even ask them, does that medication allow you to drive? And a lot of times they'll say, geez, I don't know. And I'll ask them if they got that prescription bottle on them, if I can see it. And most of the time they'll show it to me, and I'll read, and they'll say, yeah, right here it says you're not supposed to be driving.
I think, too, one thing that we need to mention as well is that for the first time person who's got a first-time DUI, you're looking at, it's a Class A misdemeanor, right?
Yep.
That's punishable by up to 364 days in jail
Yes.
and or a $2,500 fine, right?
Yes.
So, I mean, you're looking at some serious ramifications.
And that's before you even get your attorney involved.
So
The remedial classes for alcohol.
Counseling, if
Counseling,
needed.
your evaluation,
Yeah.
and your treatment.
Lost time from work. I mean, it's a mountain and a mountain of expense that it's hardly worth it, that's for sure.
And like they say, a lot of times when I have people under arrest for DUI, I'll say, hey, next time, take a taxi. Even though it might be $100 out of your pocket that night, it is nothing compared to what you're going to go through on a DUI.
Sure.
Spend that $100 or have a friend drive you home that hasn't been drinking because
Right.
you don't want to drive.
And the fine
Very
is-
expensive. Not only that, somebody can get hurt.
Yeah.
Yeah, there's a radio personality, and I won't mention the name, but was arrested for DUI, and I believe he got out of it, but from that point forward, he hired a driver.
Yep.
I mean, this individual has the money. Even if you don't have the money, the one time you take that
Great
taxi
investment.
is a great investment. It could save you thousands pain and suffering that,
Sure.
that you go through when you get
Yep.
a DUI. It's just
You better believe
unbelievable.
it.
And you
It's
might
worth
hurt
the taxi.
somebody or yourself.
Or yourself.
You
mean,
kill
that's-
somebody, God forbid, and then you're looking at some serious problem.
Then you're not talking about a Class A misdemeanor anymore.
No, you're
Then
not.
you're talking
You're looking
about
at a
felony.
felony, losing your freedom.
Talk about some
Big
of the
consequence.
felony penalties.
Well,
What
you
are
know
those?
what? I'm going to leave this up to you guys because you probably
Jesse
know better
Briantes.
than what I know.
What are we looking at in a felony?
It depends. If it's a Class 4 felony, then you're looking at up to 3 years in jail, which, by the way, a sentence of supervision wouldn't be available for you. Let's step back. In the Class A misdemeanor, in the regular DUI situation, the sentence that's available are, a straight-out conviction, sentence of supervision, conditional discharge, or probation. Now, everything except for the supervision is a conviction and will be on your record. Technically, if you do everything that you're supposed to do, and let's assume that you've pled the case out, you made a deal, and some of the residual charges have been dismissed as a result of you pleading, you have to pay a fine, you have to do your classes, and all that other stuff, right? So what you're going to end up having to do, all right, in addition to paying everything else, is to complete everything successfully. Generally, it's for a term of a year. It could be longer if the person is younger. I've seen judges stretch out the supervision maybe for a couple of years. And as long as you do everything you're supposed to do, and as long as you don't get in trouble, get another
Right.
DUI,
Another DUI.
or anything, or it can even be any other criminal wrongdoing, then at your final check-in date, the judge will ask you whether or not you've been arrested for anything else. And as long as you haven't, and you've done everything, you've paid all your fines and everything else, you'll be discharged satisfactorily. And it's not technically a conviction. However, it's going to stay on your record. There's the way to expunge certain things, but for DUI, that's going to be on your record. And it's going to show up when you pull somebody over.
Yeah.
If you pull me over, and
We
I've
know
had
it.
one before.
We know it. Yep.
And
you can
it's-
look it up.
That's going to make you a little bit more suspicious for me, isn't
Exactly. And just to back up on your question with the felony, for me to do a felony DUI, you're looking at your third DUI. You're looking at if you're driving on a suspended or revoked driver's license, if you're involved in an accident that caused injury or a fatality or a death. So there is ways that we charge the felony. We do have to get approval from our state's attorneys to be able to charge it, but majority of the time you are going to get those because it's meeting those requirements. Not only that, you get the chance of having a felony, but also we get the chance to take your vehicle from you, which is another aspect of it. So you talk about your expenses. You got a nice car you're driving and you're on your third DUI. That car, we're going to try seizing it. And majority of the time, we'll get that car. And then that becomes our property, and we sell it, and it becomes
Right.
the property of the village of Itasca.
Hopefully someone is scared straight out there by all this
I sure hope
DUI
so.
talk, and hopefully it's been informative. Thank you for joining us, Officer Cawthor. Greatly appreciate it.
Thanks
for joining
Appreciate
us.
it, both of you.
For Jesse Barrientos, I'm Dave Siegel. We'll see you next time on Legal Action.